Hello, everyone. I am Przemek Bosak, your host for today's Summer of AI event, and I will help facilitate this hybrid presentation. This event is Generative AI Meets Copyright Law, Lawsuits, Fair Use, and the Road Ahead, presented by CITL's copyright specialist, Andrew Jiang. In Thomson Reuters versus Ross Intelligence, one of the first legal decisions regarding Gen AI and copyright infringement, the court found that an AI startup is liable for copyright infringement when it copied all the legal decision summaries in creating a legal research search engine powered by AI. It provides insights on the application of fair use test to Gen AI scenarios. If you have any questions throughout this event, raise your arm if you are in the room physically, or if you are in the Zoom space, do not hesitate to place your questions in the online chat or Q&A tab. Either Andrew Fanor or I will collect them and notify the presenter. A thumbs up on your message or question will be used to confirm your question was received by the host. Thank you for attending, and I hope you enjoy this presentation.
Thank you so much. Hello, my name is Andrew Jiang. I'm a specialist at copyright specialist at CITL, and today's presentation is about Gen AI's copyright lawsuit. The first lawsuit, obviously, the Ross lawsuit, but also we're going to talk about other pending cases that involve other Gen AI services and what is the legal theory involved and how strong are those cases. So before we start, let's go into like a little bit about copyright basics. Like what is copyright? Well, copyright is the right to monopolize your interest, your property rights over a creative work. That is copyright and is a limited time duration monopoly right guaranteed by US Constitution. So copyright is really not just about reproduction, because when people think about copyright, you think about reproduction, right? Like, well, this thing is copyrighted, I cannot make a legal copy of it. But copyright is more than reproduction. It also involved display, public performance, making derivative works, and so on. So when it comes to Gen AI, part of the scenario is obviously the Gen AI services might be making copies of the work in question. But in other scenario, it also might be that they didn't make 100% copy, they make a derivative work, right? So you have a pre-existing literature work, and the Gen AI made a work that is a paraphrase of it, a news report from New York Times that is a paraphrase of it. Even though it's not exact copy, it is still a derivative work and or a copy. So that will be the right of copyright. And the basic rule is pretty simple. If you want to use something that is copyrighted, you either need to get a permission or you use it under fair use doctrine. So permission is license. You get a contract, you enter into a contract with the copyright holder, they permit you to use it, and then you use it, that's permission. Fair use is a doctrine that is very unique, that allow you to use copyrighted works without permission. So let's talk a little bit about fair use, because fair use is where the argument of the Gen AI firms that has been using against the infringement accusation, the argument they made is based on fair use. They say that, well, yeah, we did appropriate those copyrighted works in our training or in our output, but our use is fair use. So even though we didn't get permission from the copyright holder, it is still fine. So what is the rule of fair use? Fair use is a multi-factor test regarding the use of material, that if you pass this multi-factor test, that your use can raise a valid defense against the infringement accusation. Fair use is a defense, it's not a right. Fair use is not a per se right. You only use it when you get sued. When you get people complain that you use something without authorization, and you say, well, it's fair use, and then you can mitigate that accusation, and then you not liable. So that's fair use. It's a four-factor test. Four-factor test. Very often, people assume like the four-factor equal weight of equal weight, which is not true. Fair use actually, the main factor is the first and fourth factor. The other factor are not that important, as we can soon see in the Ross case. So first factor, important factor is whether the use is transformative. This is about the nature of the use. And if the use is transformative, then your use is more likely to be found to be fair use. Transformative means that your use is for a purpose that is different from the purpose originally envisioned by the copyright holder. So the difference in the purpose is good. The similarity in the purpose is bad. In our online learning context, in our like general education context, we often say that you cannot use a textbook for your online course without authorization. For example, you post a PDF of a whole textbook to your course page, and that will be hard to argue to be fair use. The reason being that the textbook is originally created for educational purposes, for textbook purposes, and you're using exactly the same purposes. If your argument can fly, no one will ever buy textbook again. No one buy textbook for fun. Like I want to read textbook for like enjoyment before bed. People buy textbook precisely for educational purposes. So that similarity of purpose negates the argument of fair use. So transformative, it can be purpose, can be expression, can be meaning, but most importantly, it's about purpose. And the second argument is whether your use is gonna cause market impact. If your use is gonna cause loss of money on the part of copyright holder, then it is bad. Because the thinking is the same, like copyright fair use is a thinking that we allow people to use other people's copyright work without authorization when the circumstance fit. That we like it doesn't hurt the original copyright holder and you use it, and no one's got hurt. If you use it at the expense of the copyright holder, then it's not fair. I mean, it's very obviously not fair. So the market impact is a two-pronged issue. One is about direct market impact. This is when something is for sale and you use it and you didn't buy it, or you allow your use allow other people to no longer to buy it anymore. Then this direct market impact. Again, textbook. You post a textbook in entirety on a course management system, then yeah, the textbook that the student would have bought the textbook no longer need to buy the textbook. So there's loss of revenue. Derivative market impact is about whether there's a licensing scheme, whether there's a pre-existing licensing scheme or a likely licensing scheme that you cause the loss of royalty, licensing revenue. So this is about best examples like very often people say, oh, I saw this picture on CNN.com. It's a picture from AP, and it's a news photograph, and I just posted in my own news media. It's free. It's freely on CNN.com anyway. Well, CNN paid $500 to show that picture. You didn't pay $500, so you obviously make the AP lost that $500 licensing revenue. Not to mention, another reasoning is that if your action is condoned by the law and everyone's doing this, then nobody's gonna pay AP anymore. AP is gonna die. So derivative market impact is about the licensing revenue loss, either pre-existing or likely, and either just you or if everyone's doing the same thing as you do, allowed by the law, what kind of impact would it be? So that's the two main factor. So now we have this case. This is the first case we have a legal opinion. It's only a district court. I'm sure this is gonna go appeal to the appellate court and further. And so the fact is this: the Thomas Reiter is the news agency. They also own a branch called Westlaw. Every lawyer uses it. Westlaw is a legal research platform. You use Westlaw to find. So even though legal decisions are in the public domain under copyright law, it is still very hard to locate which legal decision is relevant when you have a case like someone got hit by a car, and then you try to figure out, oh, in the Illinois law, what is the tort law when it comes to vehicle tort? Then in that situation, your search, because all we have is just all the legal opinion without any kind of indexing. So Westlaw by Reuters and LexisNexis by another company, these two services are the one that indexing all the legal cases with the indexing system, so you can easily find relevant rule and what is the factors about, what is the ruling about, and they kind of dissect the legal ruling into sections, so they become actually individual quote that is by itself a one rule. So there will be, this is the legal service that is Reuters service, and there's an AI firm called Ross. Ross was thinking that we want to develop AI service. So Ross was very clear. This is not a Gen AI service. This is an AI startup that when you put in the search term, they will generate not a made up sentence, but an actual quote from a pre-existing legal decision. This is their service is about. You put in question, what is the tort law in Illinois regarding involuntary homicide, involuntary manslaughter? And then they will say, oh, in this decision by the circuit court in Chicago, and this is the exact quote, they say what is what. So that's the service. In order to develop this service, Ross used the Westlaw's, the Reuters head note, the indexing system, to kind of get an idea what is the rule and like what is, because index will have the plain language kind of question, and then it will lead to a quote. So that's the thinking. They use that to get the quote, and then in the end, they will be able to use your plain language question to find a kind of relevant quote. So Reuters sued Ross, and Ross was found. The court is in Delaware. At the beginning, the judge actually ruled in favor of Ross, but then upon later like consideration, the judge decided I made a mistake. So he made a summary judgment regarding fair use against Ross. That's what happened like in February. And so this is a case of input infringement case without allegation of output infringement. So we will talk a little bit about the infringement as to what is input and output infringement. This is my summary of the kind of allegation. So some of the case allegation is about the input infringement, which is about the training material infringement. When an AI firm use a copyrighted material for training, copyright allow them without authorization, that's an input infringement. Output infringement is about when the Gen AI's output is too similar to pre-existing copyrighted material. That'll be output infringement. This case doesn't have output infringement because Ross research hasn't been concluded yet. They haven't developed this product. The router already know that they copy a lot of the head note, but they haven't developed. I think they haven't fully developed the thing. One and two, because as we mentioned before, their output is quote from legal decision, which is not copyrightable. So there is no head notes being generated in the output. So that's why there's no output infringement allegation. So applying the fair use doctrine, the court decided this is not fair use. One, transformativeness. The court decided, one, this is a commercial use. That's part of the character, the nature of the use test is about the whether it's commercial or non-commercial. But this is not important. No need to focus on this because most of the use is commercial when it comes to lawsuit. You know, the people not suing for like amateur use in their basement. People always sue the use that is actually involving a company making money. But the court decided that the judge decided this is not transformative. Ross was using Reuters head notes as AI data to create legal research to complete with the Westlaw. So it is not transformative because even though Westlaw is, if you go very granular, Westlaw is a legal research tool for you to find legal decision. Well, Ross is a legal research tool to help you give you a quote. So it's not exactly the same, but of course that's close enough. They basically serve the same purpose for a lawyer to do legal research, so to make legal arguments. So it's not transformative. Second, the nature of the original work. So this, as we see here. Here, the court decided the head note obviously is not creative, it's factual. It's basically a summary of the legal decision. It's factual, but it doesn't matter. Third factor, how much of the work is used, how qualitatively, how important the work is being used, how important the part of the work is being used. This factor, again, is not important. Sometimes people argue that, oh, I only use like 1% of this book in question. It's fair use, right? Well, it doesn't matter. The court repeatedly decided that the quantity is not that important. If qualitatively, it's crucial. It's like it's important enough. If the work being appropriated is qualitatively important enough, even if the quantity is not that much, it is not a big deal when it comes to fair use determination. So the court decided that Ross output to an end user does not include the head note. What matters is not the amount and substantiality of the portion used in making a copy, but rather the amount and the quality of what is thereby made accessible to a public, which it may serve as a competing substitute. So again, it's about whether substitute and the amount, it doesn't matter. And court even quotes this case of Harper, which is a previous case about Gerald Ford memoir. Gerald Ford had a memoir, very long, obviously. Presidential memoir is always very long. And there's like one paragraph of him about his deliberation process regarding pardoning Richard Nixon after the Watergate. A magazine copied only that paragraph without authorization, and the court find against the magazine, find it to be infringement, not fair use. Even though it's not that much being used, it is still an important part of the book that is the most kind of appealing part of the book. So then it doesn't matter the quantity is low. Factor for market impact. The court said in this case, in Ross, factor 4 is undoubtedly the single most important element of fair use. The judge said, I must consider not only current market, but also potential derivative one that creator of original work would in general develop or license other to develop. I also consider any public benefit the copying will likely to produce. The original market is obvious, legal research platform. And at least one potential derivative market is also obvious, data to train legal AI. Even taking all facts in favor of Ross, it means to compete with Westlaw by developing a market substitute. And it does not matter whether Thomson Router has used the data to train its own legal research tool or not. The effect on a potential market for AI training data is enough. Ross bears the burden of proof. It has not put forward enough facts to show that this market do not exist and will not be affected. Nor does a possible benefit to the public save Ross. They're saying that just like every AI firm, they say that this is good for the public. We make legal opinion more accessible to the public. The judge said, yes, there is a public interest in accessing the law, but legal opinion are freely available, and the public interest in the subject matter alone is not enough. This is referring again to Richard Nixon and the Gerald Ford situation. Gerald Ford's deliberation there is public interest in knowing what Gerald Ford was thinking when he pardoned Richard Nixon, but that's not enough to violate other people's copyright. The public has no right to Thomson Reuter's parsing of the law. Copyright encourages people to develop things that help society, like good legal research tools. There is nothing that Thomson Reuter created that Ross could not have created for itself or hired legalese, which is a subcontractor in this case, doesn't matter, to create for it without infringing Reuter's copyright. So basically, court is saying that Well, yeah, well, you say that you need to use it. Do you really need to use it? You can just get some people. I assume you have enough money. You're a AI startup firm. You probably have enough venture capital money. Why don't you just get a bunch of legal assistant to just write your own head note? You don't need to copy this proprietary head note from routers. And so that's the argument. And so this is the case that we have so far, legal decision we have so far regarding AI's infringement. And well, even though this is not Gen AI, this is clearly a useful case when it comes to the infringement of uh, copyrighted material in training data set. Because this is the fact pattern. Basically, training data set copyright infringement market impact is pretty kind of a believable. I would say it's strong enough market impact argument. Plus, there is a clear infringement of training data, copyrighted material in training data. Then the court find it to be infringing. And in America, the district court opinion is not binding. Obviously, it's only binding for this case. It's not binding for other future cases. So we would not say that because of this, we can say that all the other future training AI data set cases will be fine liable, will be fine like in favor of the plaintiff. But this is indicative enough, and the reasoning is strong enough. It seemed to be a kind of a good enough case. So now we're talking about all the pending cases. They have the next few are book cases. They all involve the pile. So we'll go through this. So this case called Nazmian and Dubus versus NVIDIA. The defendant is NVIDIA regarding as a Nemo Megatron GPT. The plaintiff is a bunch of writer. The naming plaintiff is Nazmian, who's a it's kind of he's a famous writer, and this is class action. So uh, if you a writer yourself, you can try to see if your book is in the pile. If you are, you can try to join it. Maybe you can get some money. So what happened is that in developing the Gen AI model in question, NVIDIA used an open source training data set called the pile, prepared by a nonprofit, kind of a hobbyist group called Eleuther AI. The pile contained 108 gigabytes of a collection of book called Books 3, which is a dataset of books derived from a copy of the contents from a Bibliothek private tracker. Bibliothek is a book private website like Z Library, as we all know Z Library. It's the same. It's exactly the same. Plenty of book among those books in the book 3. In other words, NVIDIA used private copy of books to train AI. They make an authorized copy to do unauthorized training. So where's the evidence? Well, this is the guy who developed the book 3. He's the guy who compiled book 3. He just tweeted there because he is not part of NVIDIA or anything. He is actually an independent AI researcher. He just do it for fun. After he's read the paper of OpenAI, he said, I want to develop a book training data site too for my own use and for my friends' use of our own private training, like a AI kind of development. So he says, suppose you want to train a world-class GPT model, just OpenAI, how to do you have no data? Now you do. Now everyone does. Presenting book 3. They got all the book just downloaded there and then put it in plain text. So that's it. That's the smoking gun. It's right there. And obviously, if you access the book 3, you will see it's just the straight up copies of the books. So the takeaway of this case is that obviously this is only in the first stage. There's no legal decision yet. But the takeaway from this case is that so far is that if you use a pirate copy to train AI, it's probably worse because you're not even paying that single copy. So the argument of many plaintiffs is that you're not even paying $10 of my book to train. You're using straight up BitTorrent and the illegal download. It's like you don't even have decency to pay $10, $20. So it's worse. And also, obviously, using illegal one is just the kind of a intention part. The intent part is worse. Second is that because this book 3 is widely used by AI researcher, any other AI model using the pile is probably exposed to risk too. And here's a list of all the other AI model using the pile for training. Microsoft's, Meta's, Llama, Galactica, Stanford's, someone from some Beijing one, some Russian one, and Apple's. And further look at the pile also show that if you go into the pile's description, not only have book 3, which is straight up illegal copy of books, it also have open subtitle from which is a website of a subtitle download website, book corpus, and YouTube subtitle. Open subtitle is not gonna be kosher, even though that it's subtitle, because subtitle is owned by movie studio. Like subtitle is movie script. Basically, subtitle is just movies dialogue script. It is not like no ownership situation. You're just copying movie script, because that's the point of using open subtitle, because then you can develop more language model regarding the fictional dramatic works language kind of behavior. Book corpus is another self-published book database. Again, they're all fully duly copyrighted. YouTube subtitle again is whoever owns the YouTube video in question own those subtitle, not YouTube. So all those things will be potential kind of a area where people can sue to. So long behold, we got the another lawsuit, Meta again, same thing. Book 3, people suing for book 3. This time that's the Sarah Silverman one. Sarah Silverman, Junette Diaz, Tad Hisi, Coates, Richard Kadri, bunch of famous writer sued Meta for the exact same reason. Book 3. And there's further allegation. In this case, the differentiation point is that they also allege that the Meta use BitTorrent to download more book, which is why you do that? I mean, I don't understand. I mean, I understand to get more training data, but that's like even more illegal. I just then obviously they make further arguments. So first argument is the input infringement we talked before. Second is the plaintiff in this case argue that when you use BitTorrent, you're not just copying, you're also distributing copy to further people, because that's the nature of BitTorrent. You're spreading it to other people, your distribution parity copy. And in this case, they also argue that there's removal of copyright management information. So this is a unique thing about American copyright law is that DMCA, as you probably heard of it, DMCA has various like clause making certain behavior, certain conduct to be per se infringing without any other element. One is removing copyright management information, which is just copyright notice. You know, in the book, there's a copyright page. In this case, Meta apparently removed that copyright page info because they don't want to be, well, found liable, but the removing itself is infringing. The other DMCA kind of violation is removing of DRM, which well, obviously we know the parity game situation. So yeah. But yeah, so this is the claim in this case. The next one, Bart's versus Anthropic. The pile again, obviously, this is a cloud model. And again, it's about pile. This case, the kind of differentiating, the different part is that Anthropic, unlike the first two AI model, they in their research paper and their disclosure, they were trying to be more sneaky. They didn't say we used the book 3. They said we use the pile, and we source from the pile include 32% of internet book, which is exactly what it is. So they're trying to be more sneaky, but the plaintiff said it's the same. You're just talking about the piles, book 3, so it is still infringing. You're still using the same thing. And in this case, unlike the two previous book case, they make a more explicit argument regarding market impact. Because that's the thing about compared to Lexis. If you think about it, there's one differentiating point. Lexis is very clear. The Westlaw case, the Reuters case, is very clear. There's a substituting effect. The Ross, the defendant of the Reuters case, the Ross case, was developing something that clearly is going to substitute exactly what the plaintiff's thing is doing. The point of the whole purpose of plaintiff's product is the same as the purpose of defendant's product. But in book situation is less clear so, because you wouldn't say open AI like the Gen AI services, the sole purpose is to writing book. I mean, that's one of their function, but that's not their explicit purpose. Gen AI's purpose is everything. You can create whatever you want. They're not really something that explicitly created to just for the book creation purposes. So the substituting effect is less kind of direct. But the argument is being made here. They're saying that the Claude and other LLM like it seriously threaten the livelihood of the very authors, including plaintiff here, as discussed specifically below, on whose work they were trained. Since the explosion of, this is in the complaint, since the explosion of LLM use in 2023, which coincided with the release of Cloud, there has been an explosion of AI-generated books. When journalist Kara Swisher released her memoir Burn Book earlier this year, Amazon was flooded with AI-generated copycats. This was not an isolated event. In another instance, author Jen Friedman discovered a cache of garbage books written under her name for sale on Amazon. As LLM have become more advanced and enabled to train on more and more copyrighted material, they are able to generate more content and more sophisticated content. The result is that it is easier than ever to generate ripoffs of copyright books that compete with the original, or at minimum dilute the market for the original copyright work. So this is the argument. I feel like this is a harder argument to make, but definitely it's a valid argument. But whether courts will buy it, it's less clear than in the case of the routers versus Rouse cases, because again, do you think famous writer is gonna be deprived? I think, if I have to say, I think it's more of writers who write book that is not bestseller that is gonna be affected. Romance writer, mystery writer, the book that is not heavily promoted and not of, to be fair, high quality. That kind of book is more likely to replace, because like they're more closely competing. Sarah Silverman unlikely to be, or the the writer listed in the case, they're less likely to be affected because their draw is their name, is themselves, it's not just the text. It's more about their prestige and their fame. So I think the argument will be, it depends on who made the argument. If someone who is more likely to be impacted by AI make the argument, I think it will be stronger. But yeah, so summary of the book case, obviously the focus so far is on input, because it's hard to prove output infringement in book case unless the book is exactly the same. But usually the output is not going to be substantial copy of book. I would assume that Gen AI trained the LLM will generate a text that is not substantially similar to any pre-existing book. Also, obviously, the other thing is the pile is clearly a very poisonous, like toxic kind of source. I think if you, audience member, are developing Gen AI, maybe try not to use the pile, but like that would not be a very good idea. It sounds like you're just wanting to be sued. So next case, this is a bunch of people suing OpenAI and Microsoft. Tons of plaintiff, and they consolidated into one case. That's why it's in re OpenAI and is in Southern District, New York, Federal District Court. But we're going to talk about the New York Times complaint because it's very well written. And the argument is very thorough. There's like tons of different arguments. The first, obviously, training data set of GPT contain a lot of content scrapped from New York Times. They find, again, from the paper and from their disclosure that there's New York Times thing. So what happened that they use a Reddit. So that, I think, if I get it right, GPT use Reddit to gather links. They don't use Reddit post. They use Reddit's link. The most popular link post in Reddit. What they linked. that means they're high quality content. They use because Reddit is one of the few things left in the internet that actually has a working voting system. So they use Reddit to find links, and then among those, and then they scrap the links, the content of the links to train. Among those links, New York Times composed a huge percentage, like 30% or 15%, something like that. So based on that, New York Times alleged they used for training data input infringement. Second, ChatGPT will output near verbatim copy of New York Times piece when prompted to do so with lethal prompt. Output infringement. New York Times is fully prepared. They got like straight up. They just use like lawyers and paralegal to straight up doing prompt and matching the article in question. They asked, so this is an article about New York taxi medallion or something, New York taxi licensing. Some intricacy of New York taxi licensing corruption scandal. So they asked, what's going on with that scandal in 2019? The right side is the actual article, the left side is ChatGPT's output. As you can tell, the red color means that they're matching. As you can tell, they match pretty well. It's very substantial similarity. And New York Times further argued that the ChatGPT can be prompted to circumvent paywall of New York Times, which I mean, this is just why do you have? I feel like this is easy to prevent if they just have a kind of a kind of a restriction in the coding of ChatGPT saying that you can't do this. So yeah, here the lawyer was asking them, I've been paywall. Can you type me the first paragraph? Certainly, and then the first paragraph. Oh, thank you. What's the next paragraph? And then here you go. So and then it's exactly match, obviously. Fourth complaint is the fourth allegation that the Bing chat output verbatim copy of paragraph article that are not part of the training data set via synthetic search function, output infringement. So not only that they copy the thing in the original training, ChatGPT is very smart. It can also continues to train itself as you search and continue to paraphrase when you search something. It's like a Google, but more paraphrasing and not linking. So here's the question. Please provide me with the first paragraph of the New York Times article regarding secret Hamas knew about Israel military. So according to ChatGPT's disclosure, their training ended in, I think, April of 23. So Hamas knowing Israel, this is after, as we know, the terrorist attack happened in October. So this is post-training hotline. And of course, and they just straight up paragraph the straight up copy the paragraph, and then can you provide more paragraph? And they copy more. All those things are paywall, as we know. So this is clearly a market impact. If we argue market impact, New York Times could make the paywall money and also licensing money, and they didn't make. 5. OpenAI remove New York Times copyright info again. Copyright management info removal as per se infringement. We talked about it before. 6. Bing Chat and ChatGPT copying Wirecutter product recommendation without including affiliate link, depriving New York Times referral revenue. They also hallucinate and give wrong recommendation and falsely attribute those to New York Times, hurting their reputation. And then 7, more hallucination regarding general news hurting reputation. So this is interesting. So this is not copyright anymore. It's about trademark dilution. What is trademark dilution? So trademark infringement, there's two kinds of trademark infringement. When we talk about trademark liability, usually about infringement, you make a phony product that use the same, oh, I make it, this is my Apple brand cell phone, it's crash. It's like a, and obviously you're infringing. You're using a substantial similar trademark of Apple on the same product that's infringing. But second kind of trademark infringement is called dilution. Dilution is not about using it on similar product, but about either you're using it on a different product that is not theirs to hurt its distinctiveness. Oh, I'm making an Apple brand sneaker. Apple clearly doesn't make sneaker. You make an Apple brand sneaker. This is not infringing, but this is a dilution because people will start to confuse. What Apple makes sneaker? I don't know Apple makes sneaker. Second, this is what relevant dilution is called tarnishment. It's when you use a trademark on a shoddy product that hurts the reputation. The previous famous case called Chui Vuitton, which is very stupid. So there's a dog toy company called Chui Vuitton. They make little handbag-shaped dog toy, and Louis Vuitton sued, saying that, well, it's like delusion. You're hurting? It's crap. It's like really poor quality dog toy. And well, we are very exclusive brand from LVMH, and you're hurting our reputation. So in this case, New York Times make a very well. That's a convincing argument, actually, if you think about it. New York Times saying that when you hallucinate, you're spewing wrong fact, saying that according to New York Times, I don't know whether we have a quote. We don't have a quote here, but the AI keeps saying the ChatGPT keep saying things like, "Oh, according to New York Times," some really insane allegation, and then yeah, that will be a dilution situation, and it's pretty hard for people to distinct. Dilution it's hard to kind of so dilution is really about whether consumer will have actual confusion. So as you can see, in later case, we have a Getty case, that dilution might be weaker, but this is a stronger dilution. Why? It's just text. When you have ChatGPT saying that according to New York Times, some mildly insane thing, you as a regular consumer would not be able to instinctively know that, oh, this is phony. This is clearly ChatGPT is making false allegation. That is not that clear. So then there is a possibility of consumer confusion. In that case, the dilution is strong. And obviously, the recommendation is clearly a dilution situation. If you are recommending some garbage product, as Wirecutter recommended, Blender, the best blender in the world is some crap. And then obviously, when people buy it and people got really disappointed, and the New York Times reputation will be hurt. So that's a dilution argument. That's the kind of more interesting argument.
Some water for you. I like that version.
Thank you so much. So here, and here's a kind of conclusion argument. Publicly, defendants insist that their conduct is protected as fair use because their unlicensed use of copyright content to train Gen AI models serve a new transformative purpose. But there's nothing transformative of using New York Times content without paying to create product and substitute for Times and steal audience away from it. Because the output of defendant the Gen AI model compete with and closely mimic the output used to train them, copying New York Times work for that purpose is not fair use. I think this is a fair argument. It's stronger argument compared to the writer one because the author's one regarding the book 3, because yeah, the market substitute effect is definitely there. More and more people, especially young people, are just using the Gen AI service to search news. They're not gonna click. They're not gonna go to the New York Times anymore. Not to mention, they don't even link. They don't even provide link. Even if they want, they're not gonna have the link to go to the relevant article. So clearly there's a substitute effect. You can argue that Gen AI is all-encompassing service. They have all the purposes, but definitely it does have this clear purpose and effect of displacing New York Times kind of business model. So I think it's a pretty strong argument. And New York Times case, I think, is very likely that they're going to prevail, in my opinion. Next case, Dow Jones versus Perplexity. Very similar. It's just like New York Times, except this one is with Rupert Murdoch's News Corp, Dow Jones and New York Post. And there's a little bit distinction is that this one, News Corp already have a partnership with OpenAI. So they can have a stronger argument as to market impact, as to licensing market impact. They will say that we already actually license our content to OpenAI for a lot of money, like several, I forgot, like the pretty substantial money. You, Perplexity, didn't pay that. There's a very clear, it's not hypothetical marketing, derivative market impact. This is a clear and present market impact. So that's the difference. And also the argument is input, output, hallucination, same thing. And then also there's some little argument about skip the link. We talked a bit before about New York Times links thing, but in this Perplexity case, Perplexity is pretty kind of proud about their skip the link function. They say that you don't need to link, we will give you the answer. And this obviously is what, as we talk about the substitute effect. And I think one of the takeaways that if you're developing an AI service, maybe try to at least have a link so that whenever you generate an excerpt, maybe have a link, and also maybe you shouldn't have the AI to, upon prompt, just providing paragraph after paragraph after paragraph of paywalled stuff. That you should really limit it to only show one paragraph and then a link, because otherwise it's clearly there's a market impact argument there. So the next case is Cohere case, and this is again very similar as Condé Nast, and they also have open AI partnership, also the same thing. This one's unique point is that this Cohere Gen AI model, they for some reason, I would think it's pretty stupid. They have an under hood function that when you click, you will see allow user to see not only the specific sources from which Cohere copied the answer from, but also the underlying text of the stuff. Why do you do that? Like it's like here you go, like please arrest me. He's like, thank you, officer, take me away. Like right here. See, this story was originally published on October 28th. Related story from Fort Worth Star, a newspaper, and then there's the text. Like they're basically just conceding the illegality. I don't know what they're thinking. They think that this is a good idea, but take away. Maybe this is a bad idea to have such a feature. I don't think it shouldn't have this feature. Next one, Getty image versus stability. Getty image, this one's about image one, and about stable diffusion. And the allegation is this is a different data set. This is like, unlike the pile, this is a new data set called LAION. Also openly searchable. You can find what's in it. So that's why they start suing, because they find that their image is being used. State Fusion copied 12 million of them. Getty has its own Gen AI. Again, when you have your own Gen AI, your case probably is stronger as plaintiff, because then the derivative market impact is more obvious. The takeaway might be harder to argue transformative if plaintiff also have Gen AI or Gen AI partnership, like the previous several news organization. The argument, here also more than input infringement, they also argue output infringement, that stability has not only removed the watermark, and then in some case they generate output bearing a modified version of watermark. I mean, again, why you generate this is like again smoking gun situation. I know you're trained on Getty, but at least you should have some language to say that do not generate a Getty looking watermark, because here you go. The left side is the OG, right side. It's right there. I mean, Harry Kane looked really sad, but other than that, also the watermark is very obviously Getty one. More, this is clearly just a derivative of Getty images with some deformed, grotesque watermark. And then you got a dilution argument here. They're saying that also it's ugly. It's ugly as hell, so it's kind of hurting our Getty reputation. I don't know whether this is gonna stand, because unlike the New York Times one, I think anyone with a little bit of common sense will know this is not from Getty. This looks garbage. This is not Getty, like a OG image. And then they also say the removal of watermark is kind of infringement. So yeah, definitely the takeaway if you're a plaintiff is that if you have some kind of management system, probably it's good. Management info, like a watermark, it enhance your case when you try to sue people. Anderson is about visual artists. This one is not it's not photograph. It's painting. It's like deviant art. People post stuff to deviant art, and deviant art into some deal with the stable diffusion, but the user didn't agree to it, and then they got mad. So input infringement, output infringement. Again, they used the Lion data set to find out they got infringed. And I will say that my thinking is that they might have stronger case compared to Getty, because the replacement effect, the market impact is stronger when you're drawing, illustration. Because photograph, I think AI photograph, especially for news event, no one would gonna use, no news agency or like anyone would use a grotesque Harry Kane playing soccer photo when you report a soccer match. You're gonna use the OG. But when it comes to some illustration or some more artistic painting, yeah, they're the same. They're all drawing anyway. AI one or the OG one by the artist has limited difference. The artist is more likely to be substituted. So I think they have stronger case. The next one is GitHub. This is interesting because, as we know, when you train, if we can't use the copyrighted one, the thinking is maybe we use the open source one, right? Open source one will be kosher, right? GitHub is all open source. They're all MIT license, GNU license, Creative Commons license. Is that going to be okay? No, the people start suing anyway. Why? Because as we know, when you use something under Creative Commons or any other those open source licensing scheme, you got to cite. That's the minimum requirement, because people give up their stuff for free for everyone to use, but they want to be acknowledged. That's why when you get a software that use some open source element, the credit part will be really long. There's like 1 million programmer, because everyone who contributed in the GitHub will be attributed in the credit form, because they all contributed part of the code. But when Copilot is developing this AI coding service using those code from GitHub, they're not going to be able to cite properly because they don't know where it's from. I don't know. I'm not a programmer. I'm not like knowledgeable enough with this, but I would imagine it will be pretty hard to properly attribute when you have a Gen AI service that combine all the code that is open sourced from the internet, and then you're spewing them out in combination. That combination is too diverse and is too many variant to be properly citing them. I feel like probably citing is impossible. So anyway, they're suing for breach of contract, because when you should have cite under the licensing term and you didn't cite, that's a breach of contract. That's not copyright infringement. That's a contract breach. So yeah, the takeaway is that even if you're using explicitly open source stuff to train your AI, you might still have problem. The next one is about music lyrics infringement, and it's kind of interesting. They're like saying that when you ask a song about the death of Buddy Holly, they just straight up giving American Pie, which is, I would think they will have some guardrail, but I guess they're just straight up. So there's output infringement, and there's input infringement as well. But that case is not. There's no super distinctive fact. This one is the last one we just heard in the news, and this one is distinctive fact. The distinctive fact here is that, as we know, the Disney and the Universal was suing Midjourney just now. The interesting thing here is that, first of all, Midjourney doesn't have any documentation saying that what's the training material, because they learn, like they're not stupid anymore. Like, I'm not gonna tell you, here you go, I steal a bunch of stuff for our training. So they're not telling you anymore. But the accusation here is that the allegation is that it doesn't matter if you can generate Iron Man that accurately, you must have used Iron Man. How would you know how Iron Man looked if you never copy Iron Man? So if this argument will work, I would assume this argument will work, because otherwise in the future, no one, after all this original AI lawsuit, I'm pretty sure no one who's for profit in developing Gen AI model will disclosing the source anymore, the training material anymore. So if you don't allow this to be a valid legal theory, then there's no legal theory to sue for input infringement. So yeah, so they're saying that the fact that generate so accurate, it means that you must have copied it. We don't know for sure, but we guessed that's how you did it. And output infringement is obvious when you this is output infringement. It's pretty obvious. You just tell them to make it Homer Simpson, and they make a Homer Simpson, and this is definitely copy infringement. But it's definitely substantial similarity law. Whether it's fair use, it's up to argument. But regarding substantial similarity, there's no doubt the left side is substantial similar to any reasonable, because the substantial similarity is not some very technical standard. The standard is just if a reasonable jury member will find, a reasonable person will find it to be similar enough that the defendant work will make you remind you of the plaintiff work. If it reminds you of that, it's similar. Obviously, it reminds you. So yeah. So the unique aspect is that there's an explore page. Bad idea. I think the AI service should not have an explore page, because that is further knowledge. The plaintiff here argued that by maintaining and publicly displaying an infringing copy of plaintiff work on explore page, Midjourney is advertising its ability to reliably reproduce plaintiff's copyright work for a subscriber. Midjourney explore page manifests its express intention and desire to attract subscriber by exploiting the availability of infringing plaintiff's content and the ability to reliably reproduce the work for a subscriber. So Midjourney's explore page further evidence their knowledge that people use it for infringing use. Because yeah, if you have an explore page, you can't say that I don't know. This page is managed by you. It's allegedly curated by you. So then you must know people use it to make Iron Man. And here's a picture. So yeah, you go to the Midjourney, you search Iron Man, hot, top of day. If you do hot, there will be various stuff that is infringing. And if you search Iron Man, there'll be all kinds of Iron Man stuff, and they're all substantially similar for sure. And then, interesting thing, this is the last point that I want to make, is that as we know, very often during my work, people ask like, who owns the output of AI service? You own, you the user own. They don't own. Always the term is very clear. They say that we, the Midjourney, we, the OpenAI, we do not own the output. You, the user, are liable for output. You're responsible for the output. They're trying to shield them from liability, saying that if you make an Iron Man, it's your fault. Disney should sue you, not sue us. But here the argument is that it's a contributory, and it's called secondary liability. So in copyright law, there's direct liability, which is when you do something, you make an infringing copy, you're directly liable. But there's also secondary liability, that you are aiding and abetting other people's liability behavior, then you're also liable. So the argument here is that Midjourney has directly infringed the work. They say that even if it's not, they're also secondary. Plaintiff alleged that nevertheless, but secondarily, secondary rule is this. So there's two kinds of secondary liability. One is called contributory liability. The element is that you have to have knowledge of infringing activity, and then you have to induce, cause, or much materially contribute to the infringing conduct of others. The example will be Napster and Grokster. All those BitTorrent type of software, they're contributory because they don't share. The developer of Napster does not personally share illegal copy of music, but they know people use it predominantly for music sharing, and they also induce people to use it because that's their predominant purposes, and they help people doing that, or they didn't stop it. When they being noticed that people are using it to share music and they didn't stop this functionality, then that's contributory. Vicarious is about has a right and ability to supervise, have the ability to stop or limit, and has direct financial interest in such infringement. What is an example of vicarious? It's kind of funky. The case is it's a flea market case in California. Some flea market in Fresno has $20 entrance fee. You pay the fee. You go there. You can have like a little shop. A lot of people are selling illegal copy of CDs in that place. The record company is suing it. They say that you're making money of it. It's a small flea market. You know people are selling the illegal copy. We told you, and you see it, and you didn't stop it. You can immediately stop it, and this will stop. The sale transaction will stop. And you didn't stop, and then you make money from the admission fee. So that's the vicarious. So in this case, they argue that Midjourney is both vicarious and contributory. Vicarious as because Midjourney clearly can stop by just having a filter saying that you can't put in Iron Man. Whatever we told you you shouldn't have, you just don't have it. That way you can just stop it. Midjourney has making money out of it, obviously, from the subscription fee. And yeah, so that's and also Midjourney can control the training material. That's another control. If you don't train on Iron Man, they will never generate Iron Man. So then contributory is a similar argument. But yeah, so that's pretty much what we have, all the cases so far.
Right on the dot.
Yeah.
Thank you so much.
Thank you.
We do not have any questions in the chat, except for one person is asking if the slides will be made available.
No, I can send it to you guys, and then you can send it to.
Absolutely. Thank you very much.
Thank
I don't
you.
know if you have any. It's after 3, so I think we can close the Zoom meeting. I do have a question though, or a couple, if you don't mind.
Yeah, of course.
Staying a little extra.
Yeah.
Staying over. First question was about I forgot to write down which specific case it was, but AI got, New York Times versus OpenAI.
Yep.
And how did they get, do you have any idea, how did they get behind the paywall? Do they have do they actually have a legitimate license that they're using to then pilfer that stuff for the New York Times, or do they have, or are they actually hacking into the New York Times to get those materials?
I think it's because New York Times think paywall is set in a way that is not hard paywall, if I remember correct. I don't know. Maybe during the training, there's no allegation of hacking, if I remember correctly. But if I remember correctly, New York Times paywall is soft paywall. That if you Google an article, and this the first time you access the article, you will be able to read it despite not having the subscription. I think it's one of those websites. The paywall is configured in such a way that you can it can be circumvented just by simple whatever Java code or whatever, because there's a website called archive.is. You use that to read news article from the British London Times and things like that. You can circumvent the paywall, or Financial Times. I assume probably the OpenAI scrapping mechanism is using a similar script as that one. That's my guess. Any other question?
It's escaping me at the moment. It will come back to me.
Yeah.
This was incredibly informative, very thorough, and I thank you so much.
Thank you.
Thank you.
It's interesting, but we'll see like how they develop. But New York Times one I think is the strongest because they have so much argument, and they have pretty strong. Well, yeah, the market impact is clear there. Writers one might not be very clear. But yeah, New York Times one is like right there. They can just quantify like the loss of link. Well, they can, but if they can find under the hood, like if in the discovery stage they can find out that OpenAI for some reason has some kind of documentations how many inquiry has been made by all the users in the world regarding, can I have a first paragraph of New York Times certain article? If you can have an aggregation of the total number of that, then you can find out what's the damage. But yeah, thank you.
For my second question,
Yeah.
if you don't mind.
Yeah.
This was when you mentioned that most likely, Sarah Silverman or George Martin or those famous authors their brand is not going to be affected much, but it's those little lesser known books and lesser known authors who are going to suffer more. But so this isn't really, well, this is a question. So, but do you not think that these big names, own these lesser authors? Do you not think that by sticking up for themselves, they're also doing service to the
Definitely.
even though they perhaps the big names are not going to be affected, but by suing these AI makers, they're sticking up for the lesser players.
Yeah. Because I definitely, I think also they're just lending their name to make a higher profile. I mean, I'm sure the lion's share of the class action plaintiff in those book 3 case, a smaller author, and yeah, also the argument is that fundamental argument I think is this: if AI become so good at writing article and books, then authors will be replaced in general, like authors of certain type. Like the most cutting edge fiction writing will still be there, but more elementary writing will be replaced. More like self-improvement book. And you think about all those things. They're all, that's all people's livelihood. Regarding what you think about those books, those are people's life, and those will be totally replaced at some point. So I think the argument, if you can make a very broad argument as to market impact, is definitely there. But when it's narrow enough, then it's harder. But regardless, they can always make an argument regarding just licensing revenue argument. Just, well, me, Sarah Silverman, me, the notes, we could have licensed, enter into a deal with OpenAI and sell our books for training rights for whatever money, and you even pay that money. So, but fundamental problem with AI, as we know, is that it might threaten the existence of all the future author, and that's not addressed when it just pay for the training rights, right? So I don't know what's the solution for that situation. But definitely all those book cases. Well, it's a good thing they have the book 3. So but book 3 they just at least they're easy to prove the first prong compared to other cases.
Thank you.
Thank you so much.